Can you talk please to Linda Payne? Yeah. She's got some
Thank you.
Okay, welcome. Thank you for coming to this very important meeting. And my name is Fred Vanderhook. About 14 years ago, some of us in this room, and myself, we started an organization called CAFE, Citizen Advocates for Fair and Free Elections. And so we did on a small scale with EIPCa, statewide and now others. But because of that, we decided to join with EIPCa about 13, 14 years ago. We were in existence for a short time. So it's been a great relationship to be with them. And so we'll tell you a little bit more about some housekeeping things after we have our pastor who's going to come up. And Tim Rollins, who's a straight retired pastor. Okay. Very important thing we can do is start the meeting with prayer. Tim?
Well, it's a pleasure to be able to pray for you. I know you were anticipating Jim Franklin to be here to open with prayer. He's taller and better looking than I am. But it is a pleasure to be able to start your gathering today with prayer. Just as the preamble of our Constitution starts with we, the people, that's what you all are exercising. We have the privilege of being part of a nation that we, the people, get to influence and we get to have discussions and debates and elections. And so thank you for what you're doing. But as we, the people, we need to implore for the influence of someone bigger and better than ourselves. And he is the one who, when things go the way we think are best, we can rejoice with, and when things are not going the way we want to, he is the one who gives us the patience to endure. And so let's appropriate his resources for gathering today. Let's go. Father, I love you. So grateful for who you are. I'm grateful for your availability to our needs, not only personally and individually, but I'm glad, Father, that you're also available to our needs as a nation. You have been so instrumental from the very beginning days of this country, and you still desire to be a vital part of it. And so I pray that we, the people, who are not only the citizens of the United States of America, but Father, who also are privileged to have citizenship in your kingdom, I pray that you will give wisdom to leaders and citizens here today as they discuss and plan and prepare for the most important election in our nation. And Father, the greatest part of my prayer today would be the very same words that Jesus said as he knelt in the garden, just days before his own crucifixion. And some people thought that was the saddest day in the history of his life and the history of the world. But Father, it was by his death that the greatest day occurred, and that was his resurrection. And so today, Father, as we begin this meeting, we pray the same words of Jesus in the garden. Father, not my will, but yours be done. In Jesus' name we pray. Amen.
The flag with Corbin, would you mind leading us in the flag salute?
Flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, so housekeeping items. First of all, important thing, bathrooms are through that open door over there. And there's also a water fountain. We have coffee, tea, and water over here also, some little snacks. You see, other than that, we do have another meeting at noontime. So we just ask that you exit at noontime at the city door, and then we have another meeting. And then our guests here, our speakers, have to get in their car and drive to Sacramento, so they're on a tight schedule. Also, there's 3x5 cards on your tables, and so if you have a question, please write down your question, and if you can remember to put your contact information, your name, but also your email address, just in case we don't have time to do questions in person. This way, if you write your question down, you can put it over there in the box where it says, Sean, raise your hand. It's a blue box, you put your question and your red light card in there, and we'll try to get in touch with you and answer those. Other than that, donations. We also, at the same table, we have a place for donations. So we do need donations, so that's important to stop by, and if you can do that, please stop at that table over there. Next, we have Karen Franconi. In just a minute, she's going to come up, and she is the official Fresno County EIPCa coordinator, and she's responsible for all activities in Fresno County, and so we appreciate her dedicated work, and she's going to tell us a little bit more about what's going on here. Karen?
And I'm not in charge. But I'm going to keep saying it. So I'm going to stick to my script only because I know rambles, but a lot of people know but I feel that after what Dr. Kim Rowland said, this is more of a celebration. Feels like a celebration of our citizenship. So thank you all for coming to this election integrity California, along with United Sovereign Americans on their Sergeant Strikes event, and we're number 2 on their stops to California. So really pleased and really honored to have you here. My name is Karen Franconi, and I am one of 3 EIPCa county coordinators of our election observation volunteer team. I would like to recognize the other 2 coordinators, Brentford I and Claire Diaz. If you would stand up and wave, that's part of the deal. Okay. They're so great. I think we get along great. We have a lot of fun. I know that I can speak for all of us 3 by saying that volunteering for EIPCa for the last few years has provided us an opportunity to actively participate in the governing of our state and country by helping to ensure the integrity of that part of our republic through which citizens exercise our most fundamental right, and that is the right to choose our representatives by fair and honest elections. I know that we do have a few EIPCa volunteers here. You guys just kind of wave. We can do it. Yay, thank you. Thank you for coming. I would now like to introduce you to someone who for about 14 years ago recognized that there were some problems with our state's election system and took it upon herself, along with Ruth Weiss, to take a real look and do something about it. Since then, she has spent 13 tireless years in serving all voters across the state of California. It is with great honor that I introduce to you the founder and president and CEO of Election Integrity Project California, Linda Payne.
Thank you so much, everyone. It is an honor to be here, and I wanted to point out we have a couple of coordinators from our other counties. Tom Pavich, if you can stand up. Where's Tom? Yep. Okay. Dennis. Dennis is our coordinator from Santa Clara. Okay, so we have another coordinator. Alrighty, so I'm so excited to be here. California is still where my heart is in many ways. It's my home. I run a company now from northern Arizona. As some of you may know, my mom had a massive heart attack in 2016, and we were forced to do closer care to her to help care for her. But with electronic meetings and phone calls in a car, I can still continue to drive all over to come. I'm still able to be with you. But I am really excited today to be able to tell you about what's going on with Election Integrity Project California. So let's go ahead and start the PowerPoint. And the coming and being in person. I know this is live streaming, but really excited to get a lot of people to be able to listen in without having to drive. But, you know, but because you guys are here in person, you'll be able to hear also from audio director. We're gonna talk about that for the end. But right now, what's important is all the work that you have done in California. This came on. Sometimes you wonder what's going on, what happened to my IRs, where we have the lawsuit. So the Election Integrity Project California continues to be one of the best bets in the country. No matter what we do, no matter how well we do it, the media will not talk to us. They won't carry our stories. They won't carry the press releases. And one has to wonder why that is, because of all of the lawsuits that were filed in 2021 after the 2020 fiasco. Ours is the only one still in court. And that is because of all of you cannot get in court unless you have standing, and you cannot be able to stay in court and work your way through unless you actually have evidence. All of those incident reports that you have provided is evidence that keeps us in court. So, let's see which one I did. So, at the very beginning, you go on the landing page now. Okay, there we go. So I've already come back to some background, so now we'll go to the second one. Okay, so I'm gonna let this just camp here. This is about the Ninth Circuit Court of Appeals that we are now in the process of going through. How many of you had a chance to watch the hearing? We sent the link out, so some of you did. So I'm gonna walk you through what happened, but before I get there, I want to actually walk you through the process of filing that first lawsuit in 2021. Our lawsuit is about procedure. The requirement for an election is that there be integrity in the electoral process. And integrity in the electoral process looks like a vault. It is where we have the ability to choose those who represent us. Our choice goes into a vault that cannot be tampered with and cannot be changed. But our legislators have passed laws since we started back in 2012 that have slowly taken that vault and turned it into a SID. A SID where all manner of information can come in and go out, and has made it impossible for citizens to actually choose those who represent us. So in 2020, the fiasco, we filed a constitutional challenge, challenging all of California's laws that have established the election process in California, the Secretary of State's regulations that now govern how to implement the counties implementing the laws, and then the county policies and procedures for implementing the laws and the regulations. And we've identified, even back in by 2020, that they worked together to create a system that is more smoke and mirrors than it is a true election process. So we filed a lawsuit 21, the judge who we were assigned heard the case in May 21, immediately said, no, they don't have standing. That's what they were all saying in 2021. No standing, no standing, no standing. So we appealed to the Ninth Circuit, and through a 16 to 18-year time frame, all of the written briefs were submitted, and finally there was oral arguments in November 2022, and the three-panel judge panel that heard the issue of standing ruled that not only does the EIPCa have standing, but we have strong standing. And that is because from the very beginning that we started the company, we knew that we had to go through every jurisdictional level to give them the opportunity of looking at our evidence and hearing our concerns, giving them the opportunity to take action and fix it. So we started with the county level registrars, we moved up to the Secretary of State, we moved up to the Department of Justice, the Department of Homeland Security, and by the time we hit 2020, we had provided so much evidence to legislators as well. No one was doing anything about it. So we decided to file at the next level up is a constitutional challenge to the entire system. Well, that, when the Ninth Circuit heard our oral arguments in November, because we had taken the time to do that, and because all of you who took the time to observe and document every single election from 2012 all the way up, that gave us strong standing. And us doesn't mean me and Ruth. Us means all of us together, because it is your evidence that is keeping us in court. So they sent us back to 2023 started to study. 2023, we were supposed to have been able to audit the 50 counties. We were supposed to have been able to get discovery from the Attorney General and the Secretary of State. And most of the year, the attorneys for the state and the counties just continued to banter back and forth and play all manner of games until about August. The judge once again tried to dismiss the case. And he dismissed it saying that our evidence was nothing but garden variety clapping and whining. So we immediately appealed to the Ninth Circuit again to see what this one's all about. And not only is that judge wrong, he's just trying to get us off his docket. The fact of the matter is, from the 2020, 2021, and 2022 elections, the EIPCa has 10,000 signed affidavits from citizens from 43 out of 58 counties, as well as citizens who have moved out of state and submitted citizen statements documenting that they are still receiving ballots or even emails from the Secretary of State with an attached ballot saying it's not too late to vote. So the level of documentation is deep and wide and broad, and it incorporates so much information. Of the 43 counties, we represent 85% of the California population. So there is no way that this documentation is guarded for already laboratorial. So as soon as they dismissed the case, Mariah immediately filed an appeal to the Ninth Circuit Court of Appeals again for the second time. Within a week, I contacted Mariah and asked her if she would please request an expedited procedure. And I asked her, representing the client, which is the EIPCa and all of you, to let them know that we believe this is judicial tyranny, that we have done everything right, everything required, crossed our T's and dotted our I's. We've patiently gone through what we're now calling a marathon of the court system to do all that is required before we get some kind of opportunity to present the evidence to the courts. And we asked them to expedite it. So within a week, they did in fact expedite it. So instead of 16 to 18 months of going through the process, they sent a memo to the attorneys for the defense and for the plaintiffs saying mid-September that the first brief was due in 2 weeks in September. And then the next two were due in October and November. So by 3 months, they had completed all of the requirements for the written briefs. Folks, that's a miracle. The Ninth Circuit doesn't do that. They did it for this case. And then they scheduled the oral arguments for February 9th. Another example of really stretching out. That tells us that there's the Ninth Circuit in general is looking at this case as critically important. The sad thing is, on the day of the hearing, so some of you saw that, you were able to see the 3 judges sitting on the stage. Actually, it was 2 on the stage and 1 on the video, on the other 2. And then there were the 2 attorneys for the defense. The judge sitting that was in the middle, you could see she had papers, those of you who she was good. That was our complaint. That judge had read the complaint, understood what was in the complaint, and understood the connection of the entire electoral process. The other 2 judges, it was pretty good, they never read it based on their questions. And then the other 2 attorneys. So when Mariah went up to present her opening arguments, she was interrupted almost immediately, covered with questions. So instead of being able to get through her opening, she had to pause and answer that question, answer this question, the other question, to where she couldn't actually complete the opening. And that was the game plan. I don't know if some of you dedicate one of the strategies of debate is to throw your opponent off center, so they go from thought to emotion and be distracted, and that's exactly what happened, right? So even if she had a chance to complete it, she was losing her train of thought. But they did let her complete it, they called time before. So there are 2 important elements that Mariah was able to put into her opening. Number 1, as the issue is with the vote-by-mail voting system and the ballots that were being processed. And she called them the right to deal in ballot ballots. Now, we learned that from USA County, and what they do, and I don't think you want to understand, but that was something we never heard before, that ballots need to be valid. We know from the voter rolls, we have massive names on the voter rolls that are not real names. They're duplicates, they're not people, they're duplicates, they're deceased, they're names on a spreadsheet. And so when those names on a spreadsheet receive a ballot, and someone marks them, and they get sent through the process, and then they're counted. That's what our lawsuit's about. Those, ineligible ballots are being counted as equal to United States citizens. And that's what we're saying. This system is unconstitutional because our ballot our voice is being diluted, by being equal to, it's paper. So, but before she could say that, they ended their time. And then she said, that's okay, my rebuttal, I'll cover the voter rolls. Well, she needed to be able to cover the voter rolls because she needed to tie the voter rolls together with the invalid, illegitimate ballots. And so by the time the other two attorneys did their opening, with no talk, they went straight through, nobody had any questions. They finished, and then Mariah came back around for rebuttal. And before she could get to the part of talking about the voter rolls, the judge who had more lawsuit had come and her, she immediately did said, okay, we're done. And bye, see you later. And so we are looking at that as saying they prevented Mariah from actually representing the client, the EIPCa in the Ninth Circuit. So right now we have two options. Mariah may still vote in our favor, because there's no question that 10,000 signed applications from citizens from 43 out of 58 counties is not garden variety document. We have realized that says they know it. So this item what took place in hearing, they may still rule in our favor. In the next 2 months, the Ninth Circuit will debate and deliberate about about what was in the hearing, but they also have to include our briefs. So it's possible also will not favor, but if they don't, go ahead. Actually, if they don't, do not, I think that's to be decided. Let's go ahead and get all of them so that we can just have them closer. In this slide, each time you get forward, you'll open up a new piece of this. Yeah, here we go. Okay, so I wanted to talk just for a second about the evidence. What kind of evidence do we have, and how is it that it's not coming from Haiti? So in our work, beginning in 2011, when we first started studying the law, federal law, state law, how does this thing work? We identified that through federal election law, state election law, county registrar's policies and procedures, and the Secretary of State's regulations, that these elements of the election process are being negatively impacted by these laws and the system we have now put in place, a 60-day election season that can be manipulated the processing of the ballots is what we're challenging. So go ahead to the next slide. And again, go ahead and click that. So what we've documented over time, the first one doesn't say everyone, but the provisional ballots beginning in 2012, California passed 40% of all provisional ballotation. Now, you don't pass the provisional ballot unless there's a problem. So for California to pass 40% of all provisional ballotation, that's a problem. By 2016, go ahead and click, Matt, click all the way until all the circles are up. There you go. So by 2016, California had passed 60% of provisional ballots nationwide, which tells you that the system, as we have been documented, thankfully to you, we've been documenting that the system kept getting worse and worse and worse because of the legislators who continue to pass election laws that took a vault and turned it into a state. So I won't watch too much. Most of you are very familiar with what we do, but that is what all of those reports. These are the issues that we documented. This is not our right. It's like, so this is what we're filing. Because of that level of evidence, if they rule against us, then the lawyer will file an en banc hearing. And an en banc hearing is the hearing of all of the judges of the Ninth Circuit. Next slide. So federal appeals courts will sometimes grant a rehearing to reconsider the decision of a three-judge panel of the court in which the case concerns a matter of exceptional public importance, or the panel's decision appears to conflict with a prior decision. Where there is no prior decision, because no other lawsuit like this has ever been filed in the history of the United States. And that is because no state has taken the time and patiently gone through the system to document and present the evidence. And again, that's all of you. And I know how all of us are frustrated at times, man, this is taking so long, what's being done, what happened to my IRs? And so I'm so glad you're here, because this is what's happened to your IRs. We have accumulated and built them. And the 10,000 are just from 2020, 21, and 22. We have as much or more from 2012, 2013, 2014, 2016, 2018. So when we get into court, there is no state that has this level of documentation. So what we're looking at here is concerns a matter of exceptional public importance. And that's why there are those who are activist judges who do not want this to go forward. They know that judge in the middle who was looking at our complaint knew what we have is all the complaints are so that was that. So go to the next one. I'm going to give you a second to hear from Mariah and Robert Conley, the president of Advocates for Safety and Freedom. When we first filed the lawsuit back in 21, and it took us that long, because we couldn't get judges. We were ready to file our first lawsuit in 2013. After the 2012 election, we had enough evidence, and we worked with Jacob Shenanigans, better election law in these countries. He looked at our evidence and he said, you have it. I'll have you file it. I'll put it together, but I need a California lawyer, because I'm not licensed to practice law in California. We could not find a California lawyer who would work with Jacob Shenanigans and just simply file the papers in California. We would have been so much further along if we could have found it. And that's going to be something we're talking about when we say we need lawyers to be able to get involved. Well, after the 2020 election and our conversations with many lawyers, it's a young lawyer advocate from Joshua Cruz. And I'm going to look. There was Joshua Cruz. He and two other lawyers were part of a nationwide national law firm that was going woke, and these three lawyers didn't want any part of it. They resigned and started their own law firm called Primary Law. And Joshua was the first true lawyer to take a case like this forward. We worked with Steve Area, some of the early filing of Fresno and Ventura County, but that was sort of a smaller type of law, but a constitutional challenge. So Joshua Cruz, the first year, we were able to raise $100 million to cover the cost. Joshua wrote out another $500,000, and that's what it cost to get these officers across the finish line. But because he couldn't continue to carry us, Advocates for Faith and Freedom stepped in. And Advocates for Faith and Freedom is a public interest law firm. They raise their money donations just like we do, but they are now our attorneys. But I'd like to, you ready now? I'd like to President City.
I'm Robert Tyler, this is Mariah Gandiro. We're Advocates for Faith and Freedom. We're a nonprofit law firm. We are proud to represent the Election Integrity Project, California, and possibly doing some work in other states as well, including Payne and the team. We are grateful for the support we received as a nonprofit organization. We rely on donations to be able to accomplish what we're doing, just as does the EIPCa. I will first talk about one of our cases. We went to trial in Ventura County, and in that case, it concerned the fact that, in our view, Ventura County election officials impeded the ability to observe the elections in 2020, 2022, and will likely do so again in 2024. In that case, we were able to prove that the right to observe was significantly impaired and impeded by the actions of the election officials. They created zones where individuals they can only stand in certain zones when they're observing signature verification. There really was no observation other than to be able to see that an election worker was sitting in front of a computer. But it was impossible at times for our clients, these election observers of the EIPCa, to even see the screen. They could have been playing solitaire on their computer for all they knew. And so we presented all this evidence to the judge, and unfortunately, the judge seemed to take the standard in his ruling that so long as the observers could observe the election workers working, that was enough. And we argued that certainly was not meaningful in terms of its observation. We argued for a standard for meaningful observation, not something that is just merely being able to see whether someone's sitting in front of a computer, but being able to observe their work itself. The judge was unwilling to go that far. So we are up on appeal. This is a case of first impression based upon the new standards in California that we've had over the last few years. So there's no court of appeal decisions to really decipher, define what it means for meaningful observation. So I would encourage all of you election workers who are going to be out observing to consider that. We believe that common sense deems that you should have the right to be able to do more than just see whether somebody is actually sitting in front of a computer, whether somebody is looking at envelopes. You should be able to see that they're doing their job correctly. That's meaningful. And so keep track as you're going through and you're observing. We'll want to note every time that you are impeded in some way from determining whether someone's actually doing their job. Not whether you have the necessarily, not that you have the right to be able to declare a signature invalid, but be able to determine whether or not there's any meaningful review of those signatures. Next, we just a couple weeks ago, Mariah Gandiro argued in the Ninth Circuit in a federal case. So why don't you give us an update on that?
And we're one of the only developed countries that has an election process like this. Even Mexico has a stronger election process than the United States, which to me is really sad. I think the United States should be paving the way for election integrity, and we should be far advanced than most developed countries. And instead, we're allowing all these procedures to take place, knowing that there's a lot of ways that people can manipulate the ballots.
We are looking forward to this next election, and please keep track, all you volunteers, lawyers, please keep track and really keep a close eye, take copious notes, and report them on the complaint forms that you're provided by EIPCa. By the way, in our trial in Ventura County, those report forms were very important to us, weren't they? Right. We're able to use those forms and have witnesses on the stand to be able to testify as to what they observed. And it was very valuable, and I think Lord willing, we're going to be able to reverse that case because we have plenty of facts in that trial. So we'll see, hopefully we'll create some better standards in California, but we're seeing the same sort of thing all over the country. And so in other states as well, we will hopefully be able to create some better laws so we have a meaningful observation minimum. Thank you all you donors who have donated to EIPCa because they're helping to keep us afloat as well. We have donors and EIPCa has some donors who are able to contribute to help us be able to pay our expenses as we move forward. Thank you all for being a part of EIPCa. God bless you.
So everyone, that's the second case that we have before, and a lot of people don't care about that one, but this is important to every county in the state, that includes you guys. And throughout the years of observing, we've heard incident reports and testimony from some of you with frustration that in some counties, you simply weren't being allowed
to be close enough to see, some that stand 20, 30, 100 feet back of time. Others like that, sure, they actually put chairs and tables in front of the windows where they're doing the adjudicating of the ballots. And so we chose Ventura County for this lawsuit to represent the issue in every county in the state. So this is an important case for you in Ventura County and all the counties as we move this forward. The other thing why this case is so important is, once again, there is no other case like it. There's no precedent. No one has filed a lawsuit like this challenging the lawful right of citizens, or I should say, challenging the registrars from preventing the lawful authority of citizens to observe. Only 29 states have the lawful authority to observe. Arizona's not one of them. In Arizona, we have to sit on our hands and wait for the parties to set somebody on election day. The 27 days of early voting, nobody gets there, and we're not allowed to be citizens. So we are working on passing legislation in Arizona that you already have, and I say that to you because I really hope that all of you will be able to appreciate how important it is to live in a state where we have the right to observe, not on behalf of a party, but on behalf of a group of people. And your incident reports and their incident reports were so critical in a 5-day trial in Ventura, laying it all out before the judge, and that's what your incident reports will do. So we'll see where that goes. Next. So as California laws continue to remove integrity from the electoral process, Election Integrity Project California continues to work to ensure that every lawfully vote cast, every lawfully cast vote is actually counted. And that is our motto, because that is the basic understanding of what we do. Only lawfully cast ballots should be counted. Next. So something pretty amazing happened in September. We've been doing this work forever. We studied all the law, HAGA, National Voter Registration Act, everything we need to study to start this work on its way. And we looked at the federal requirement that electoral process needs to be surrounded by integrity, and that's where we got the whole idea. But I got a phone call from some guy named Mark September, telling me about what they're doing on the East Coast and throughout the country that follows a body of federal law that I never heard before. It's the federal prosecution of election offenses. I wish I heard that earlier, but I didn't. And hearing that for the first time gave me hope. So I began to go on the Tuesday calls and all that, and began to understand what this body of law is for the first time. I had real hope, because we know that our lawsuit is a marathon. Now, a 24-mile marathon, we're about mile 20, so we're getting really close now to finishing. If the en banc review still goes against us, we will appeal to the United States Supreme Court. So EIPCa is not rolling over, we're not rolling away. We know we have the evidence, and I wanted to show you all that so you know that we have the evidence, and that you all brought it to us. This is your work. But still, we're in 2024, and what if they push our lawsuit down to 25? What about 24? So talking to Molly, I realized what USA is doing is the piece of the puzzle that lets us hold election officials accountable. Our lawsuit holds the offices of election officials accountable for the process, but they don't care. When we filed the lawsuit in 2021, 3 of the registrars of voters immediately retired and moved on. So nothing happened to them. So anyway, go to the next one. I'm going to get back to that in a minute. But I want to tell you what we started doing after our my meeting with Marty and looking at some of those and realizing what the strategy was doing. I immediately contacted our data analyst team, who we've been researching data since 2011. And I said, we need to do this. And we decided to do it, we got started. So EIPCa's data analysis group has been hard at work reviewing the state's voter rolls via the federal and state election laws, using the guidelines put forth by United Sovereign Americans. The EIPCa is now working shoulder to shoulder, and our volunteers, as they work for USA, they take off the EIPCa hat, they put on the USA hat. We've never done this. Those of you who work with us a long time, we don't do that. But I'm so convinced that this work with USA is going to help us in California sort of put the pinchers on. We We've got the federal law, that's not going away, but this is the sprint. This gives us a chance to do something this year. Next. California is the nation's largest state and has 27 million registered voters. A huge success for the EIPCa was the 2018 settlement of our lawsuit against the state for mismanaged and inaccurate voter rolls and the subsequent actions required of the state due to our win. Since January 2019, not only has the state removed 1.5 million inactive status registrants per our settlement agreement, our latest data from October 23 shows the state has actually removed 2.5 million inactive since 2020. The inactives were as high as 5.4 million in mid-2020. They are now 2.9 million. It's a new low. And in 2020, we sent the Secretary of State a total of 6 research letters. We got the data before the primary and after the primary. And to show them, before the primary, we identified all the problems. We asked them to quarantine those problems and not send them a vote by mail ballot. We asked them not to count them, and then they ignored us. We got the data after the primary, and we had the data and compared it, and we identified all those problematic voters that we warned them about. We stopped having them cast the ballot. We did the same for November. Bought it before, sent a warning, asked for quarantine, they ignored us. After the November, they counted them, and then we sent to them out just to keep in front of them what their voter rolls looked like. They ignored us. Anyway, but the one thing we look at, the settlement didn't only impact Los Angeles County. All counties were required to comply. This is the good news. Below are some county changes in the inactive status of registrants as of October 9, 2023. So we have, you'll see the minuses, those are all how many of the inactives will find you removed per the National Voter Registration Act. You'll see Fresno County actually has plus 2,000. And that is because for the first time, Fresno County, and also you see the same for, Shasta, for the first time we actually took the active, the ineligible actives, and moved them to the inactive. That's a stunning thing, and that's what we work with here, and we work with the EIPCa, we work here registered voters, because part after we started bringing to the attention the registrar here, the issues in the voter rolls, only they have to ignore. But for the first time after the settlement agreement, they finally started taking care of it and moving to the inactive. So their next step is to move them out of inactive and remove them altogether. Next. This shows that clear evidentiary data coupled with a robust legal action can make a difference in the integrity of our elections. Our data analysis group has always believed and has proved the state's vote count voter registration database is inaccurate, incomplete, and therefore unreliable. And we even sent a flash drive and a report to the Department of Justice in 2020 asking them to address this unreliable state voter database, which they ignored. But our wins are bittersweet. And since our efforts focus on process, election officials are not personally held accountable for violation of federal law. The EIPCa working shoulder to shoulder with United Sovereign Americans and its scorecard approach to quantitatively illustrate our concerns and show that both federal and state election laws are being violated. And this is where I'm going to hand it over to Ron Martin. We have done everything that we can, and we're doing great work, and we're making progress, but it is bittersweet when going down from 5.4 million to 2.5, whatever that comes from. So that's a big hurrah, but there's still 2.9 on the inactive list. And we know that every one of them can vote. All someone has to do is send one of those vote by mail ballots out in that name and say, I want to vote. So though we made progress, it's still in not preventing invalid elections from being certified. So right now, I'm going to hand the mic over to Molly Cornick, and I'm going to let Molly tell you about herself. So it is really my honor and pleasure to bring Molly up. She is so much more of us. She's solved the problem just like we did. She stepped up and did something about it. And without further ado.
Thank you so much. Matt, can you go back 1 second? So it's really a pleasure to be here, and I really want to thank all of you for what you've been doing in California all of these years. It's tremendous for the whole country, and the work that you've done is so important and so significant and is making a huge difference. So I just want to thank you, because I know that it's grueling. I know that personally. And so I just want to honor what you've accomplished, doing that in itself. And I'll just introduce myself by saying, in July of 2021, I was homesteading and homeschooling my 3 kids. And I got a phone call inviting me to lead an initiative in New York State to take a look at the state border home database. And I thought about it, and I thought, well, that's really funny that someone called me, because I really couldn't figure out why they called me. So I thought it might be important. And I prayed about it, and I decided to go ahead and take that role, and I founded New York Citizens Audit. You may have seen some information about the work of New York Citizens Audit, perhaps. We got quite a lot of coverage about a year and a half ago. I presented a very important piece of evidence that we reverse engineered inside of the New York State Border Home database at the To the Vote event, the PIT. And so a lot of people heard about us through that, but really we started out by just downloading some data from New York State Board elections. We downloaded the certified counts for the 2020 general election in the fall of 2021. And it immediately started a ruckus on our analyst team because they were having this giant fight about whose numbers were correct. And came to find out that in October of 2021, 10 months after the 2020 general election was certified as accurate and legally compliant, the state was still changing the numbers. And it wasn't our analyst team that was wrong, it was that the spreadsheet, if you downloaded on Tuesday, it was different from the one you downloaded on Friday, which is pretty stunning and brazen, actually. And so we started comparing, we started thinking, wow, we might be onto something. Because we figured, gosh, in a deeply state like New York, why would they cheat? Why would they take that risk, right? If they have the voters all sewed up like that, why would they take the risk of committing crimes? So we got a copy of the state border roll database, and we took those certified totals and we compared them to the number of voters who had voted. And we discovered that there were 250,000 votes counted in New York's 2020 general election with no voter attached to them whatsoever, no record of any voter. No one had any idea how those ballots had entered the system. And there was no audit trail linking them to an individual, not even a fake one. So at that point, we were like, oh, well, gosh, we're uncovering all these odd anomalies, all these oddities. Gosh, look at all these anomalies we're finding. And it wasn't until that night at the pit, and I happened to be sitting across from Harry Howard, who became the co-founder with me of United Sovereign Americans. A great human being, a wonderful American, and a genius, honestly, who is very experienced and advanced in cybersecurity and cyber systems. In 2002, he was living in St. Louis County, and he had a business. His operation was in cyber processing of electronic transactions, and his company processed transactions for 16 of the 25 largest banks in the world. So basically, he ended up helping to write GABA, and the system that banks were using to accurately, absolutely without error, process millions of electronic transactions every day is what became our electronic voting system. Anyway, sitting across from Harry, and we, for whatever reason, we became fast friends. And well, for a lot of reasons, we became best friends, but I don't know why that happened. That's all I'm saying. But we started taking the work of all these anomalies we had uncovered. The 254,000 individual unique registrants in the New York City voter roll database who had cast a vote in the 2020 election. And you look them up, that same exact particular individual in the state database, and the vote was gone. right? All of these anomalies, and we started lining them up against federal law. We started lining them up against Supreme Court precedents that go back as far as 1888 regarding the guards that are supposed to be protecting our election systems from misconduct. And we started to create these 4 principles of law that we call election validity. First of all, the voter rolls have to be accurate. Second of all, oops, can you go back to that first slide? I still haven't actually started the slide, so you're way in. Thanks. So I'll let you know when I'm ready for you, okay, Matt? Thank you so much. So the voter rolls have to be accurate. The votes counted have to come from qualified voters. The number of votes counted has to equal the number of voters who voted. It seems obvious, but it's pretty important. And there's actually, well, we'll get into it. I'm gonna actually start to go through the slides now, because I think I've given you a little introduction into where we're headed in terms of what is the significance of our right to vote and how is it actually protected. So can you go back to the first slide, please? Well, this one is slippery. The right of voting for representatives is the primary right by which other rights are protected. That's from Thomas Paine, from the original documents around the founding in Union County. We could think of him probably in our current terminology as conservative. Next slide, please. No right is more precious in a free country than that of having a voice in the election of those who make the laws under which we, as good citizens, must live. Other rights, even the most basic, are illusory if the right to vote is undermined. And that is from Justice Hugo Black, who was appointed to the Supreme Court by FDR, you could call him a radical progressive. And all I want to say with those 2 quotes is, look, we finally have something we can agree on. Next slide. In the United States Constitution, it doesn't take a long time before you come across the principle of government by consent, because it was so central to our founding philosophers who created this beautiful country and worked. It blows my mind. You ever think about that there would be like a blank piece of parchment paper and you would pick up a quill, and without any words on that page, you would inscribe the Declaration of Independence? Can you imagine a world where that hadn't existed yet? It's so incredible to me. Anyway, the U.S. Constitution, you see that we the people right at the top, right? So that's the preamble. And then you get Article 1, Section 1, which says all legislative powers are vested in the U.S. Congress. The third sentence of our Constitution says the people of the several states shall choose those representatives. Oops. Let's go back to the Constitution. I'll promise I will let you know when I'm done. So I just want to say before we switch off that slide, that's the third sentence of the United States Constitution. Now, if you've ever read the whole Constitution, which probably all of you have, you know it goes on for pages and pages and pages, but before they could say anything else, they had to say this. The people of the several states shall choose these representatives. We shall live under rules to which we have consented. Next slide. In the 14th Amendment, we get a little bit more information. Actually, we get a lot more information, and we get the definition of a U.S. citizen. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. Great. So now we know what a citizen is. Next slide, please. In the second section of the 14th Amendment, we learned something very, very important, again, about the significance, the incredible significance of our right to vote and our right to accurate, honest, legally compliant elections. The second section of the 14th Amendment tells us that our right to vote is so sacrosanct that if it is denied or abridged in any way to a qualified citizen voter, the state that is responsible for this injury loses apportionment in proportion to the number of injured citizens. So they lose federal funding, they lose congressional representation, and they lose electoral college votes. That's a pretty serious set of consequences. Next slide, please. The Voting Rights Act of 1965 is where we start to see Congress getting involved in oversighting of elections for the first time since roughly the 1880s with the Enforcement Acts, okay? So there's a gap in our history where Congress really wasn't really that invested in the electoral process in terms of creating laws. And there's reasons for that, because as you probably know, the time, place, and manner of elections is apportioned to the state legislatures. That's who has jurisdiction over that. The federal government has no authority over administrative procedures of state elections, even though they're federal elections. But Congress has the authority to protect the rights of the citizens of the United States of America. And the Voting Rights Act of 1965 is civil rights law. And this is very important. From 1965 forward, all of the laws that Congress has passed regarding our elections are not election law. They're civil rights law. And so you have standing. And you have standing, Carl. And you have standing. Everybody in this room has standing. Everybody outside of this room has standing. And because it's a matter of our fundamental civil rights, it's the third sentence of our Constitution. Next slide, please. In 1993, Congress passed the National Voter Registration Act. And they did this for 4 reasons. And the third reason is to protect the integrity of the electoral process. The fourth reason is to ensure that accurate and current voter registration rolls are maintained. Now, why does Congress consider it to be your civil right to have accurate and current voter registration rolls? It's because voting systems are very simple. The voting system is incredibly simple. You'd be amazed if you just walked away from social media and read the law, how simple a voting system is. It contains 3 things. It contains voters, votes, and counts. That's all. That's the only thing in a voting system. Everything else is external to those 3 fundamental elements. Every tool that could be applied to manage one of the critical pieces of that system is only helpful insofar as it helps to manage those accurately and appropriately. But it has no business inside of the voting system. The only thing in the voting system really and truly is voters, votes, and counts. So the reason that Congress decided it's your civil right to have accurate voter registration rolls is because they're dealing with the first element. This is upstream. If the voter rolls aren't accurate, then the vote might not be accurate. If the vote's not accurate, then the counts might not be accurate. And then we don't have government by consent. We lose continuity of governance, we have discord and disharmony. It's a mess. So we have to start off with a document that's nice and accurate, not clean, right? It's not that it's clean, it's that it's accurate. Because people talk about dirty voter rolls, right? You hear this term all the time. Oh, dirty, the voter rolls are dirty. You have to clean the voter rolls. Like if you just had lunch, you take your plate and you put it in the sink with soap and hot water, rinse it off and put it in the drain, and now someone else can eat off that plate. But you can't do that with a voter roll database. It's not the same thing. So it doesn't make any sense to apply this ideology to it. It's very confusing. Next slide, please. The Help America Vote Act of 2002 is where our system of voting became electronic. Our system of management of those 3 particular elements of a voting system was electrified. And there's a great provision in the Help America Vote Act regarding the statewide registration lists that are now going to be computerized. And it's very clear language. I love election law, even though, like I said, this is actually civil rights law, but it's very, very clear and simple. You don't have to be an attorney to interpret it. It's called black letter law. Everybody knows what it means. And we find out that the state voter roll database contains the name and registration information of every legally registered voter in the state and assigns a unique statewide identifier to each legally registered voter. Because you can't have 3 or 5 unique statewide identifiers, right, for one person, because that's not unique anymore. Next slide, please. So before we go further into how these laws actually end up impacting our ability to enforce valid elections, we want to take a look at what the Department of Justice says about fraud. What is election fraud? right? We know what it means on social media, it means this is a bad person and this is a good person. But how does the Department of Justice actually define election fraud? Well, it's very simple. If you interrupt the process of registering voters, if you interrupt or corrupt the process of counting ballots or certifying ballots as valid, and if you tamper with the counts, that's election fraud. It's that simple. Next slide, please. In HAVA, the Help America Vote Act, also we got something wonderful from Congress. We now have an accuracy requirement for federal elections that never existed before. There's actually a line in the sand, there's now a standard against which we must measure, by law, we must measure our elections to discover whether or not the number of errors that have taken place within that election constitute a red flag. Right? Basically, if there's an X number of errors, now there has to be an investigation because it's starting to raise the specter of fraud. I don't know if you know this, and I hate to be the bearer of bad news if you don't know this yet. I hate to drag people out of their innocence, but congressional elections involve a tremendous amount of money and power. Sometimes bad people cheat. Next slide. Okay, the accuracy requirement under the Help America Vote Act is very stringent, and there's wonderful language in this law. I'm going to read it to you because I couldn't say it any better. For a voting system, accuracy is defined as the ability of the system to capture, record, store, consolidate, and report the selections made by the voter. So you see, a voter is an essential part of the voting system. They're inseparable. And the rate is set at such a sufficiently stringent level that the likelihood of voting system errors affecting the outcome of an election is exceptionally remote, even in the closest of elections. And I will tell you, the accuracy requirement under the Help America Vote Act is a maximum error rate of 1 in 10 million ballot positions. And a ballot position is a circle on a ballot. So depending on how many pages you have and how many elections, how many initiatives and all these other things, you may have a variety of ballot positions on your ballot. And so in 2005, they created a voluntary error standard that was a little bit easier for people to wrap their minds around of 1 in 125,000 ballots in error. But the original standard is law. So now we're going to start working here in the United South Americans. We're going to swap over, though, to working with the 1 in 125,000 ballots in error, because we're going to go digging into the votable databases and find out if we have a valid election in 2022. First, we're going to look at some of the laws, though. Please, next slide, Matt. Next slide. Take that one. So conduct that constitutes federal election fraud. And I'm going to read this because you guys probably can't read it too well. Voting in federal elections for individuals who do not personally participate in and assent to the voting act attributed to them, or impersonating voters, or casting ballots in the names of voters who did not vote. And then you'll see a bunch of citations there. Those are the federal laws. And if you were a U.S. attorney using this booklet, the Federal Prosecution and Election Offenses, to try to understand a circumstance that came before you, is it fraud, is it not fraud, is it prosecutable, and how would I go about prosecuting it? Well, there's your citations. Now you know. If somebody did those things, here's the laws they broke. Next slide. Conduct that constitutes federal election fraud. Malfeasance by election officials acting under color of law. By performing such acts as diluting valid ballots with invalid ones, rendering false tabulations of votes. Remember I was telling you about that story where we found that anomaly, those 272,000 voters in New York State, or votes counted that don't link to a voter? That's rendering false tabulations of votes, acting under color of law. That's what that is. But we thought it was an anomaly in 2021. Next one. Submitting fictitious names to election officers for inclusion on registration rolls, thereby qualifying the ostensible voters to vote in federal elections. See, there it is, right there. That's why the voter rolls have to be accurate. Because every name that is recorded into a voter registration database is considered validated and qualified. And now they're allowed to get a ballot. I think I have maybe one more slide. Okay, yeah, and now we're gonna go to California. Next one, please. Okay, so this is really gonna be tiny for you, so if you're a very curious person, you may wanna get closer. But I will do my best to read it to you. So this is the California election validity scorecard for the 2022 election. And this is a draft version. Okay, the team is still working. It's not quite ready for publication. That's why it says draft on it. So in case you take a picture or whatever you decide to do, you understand that these are not the final numbers, but we do have great confidence in these particular claims that are already on the card. So we're gonna go into the California voter roll database and find out if the registrants that are on that list represent legally qualified registered voters. So the first thing we find out at the top is that there are 45,000 illegal duplicates. Remember in CAVA, in federal law, remember you had a civil right to have a voter roll database that's accurate, meaning a unique identifier is assigned to each particular voter? Well, your right was violated 45,000 times. We have 33,000 deceased registrants. We don't actually know that all of them are deceased because about half of them appear to be alive, but their birth date indicates that they are older than the oldest known human being in the United States of America, who is 150. So it's not clear how they could be alive. We have age discrepant registrants, and I haven't looked at those particular records for California, but in New York, I can tell you, I was showing a file on Monday to a county legislature, and we were looking at registrants who had registered to vote when they were minus 57 years old. That's not a valid registration date. And it's very important to think about that. I mean, it looks like garbage, first of all. That's the first thing. It's like, wow, how is our country being governed by garbage? Or the outcomes of our elections are being dictated by garbage. But the other issue is that a valid registration date is material to determining whether someone is actually eligible to vote. Because if the date is false, then that means that the true date is unknown. And no one knows it. The registrars don't have some secret vault of information that they're not providing in the voter roll databases. No one knows if that person is actually qualified to vote. We have invalid addresses, and in California, we have 459,000 of these. These are not taken from like a USPS list. These are taken straight out of the database itself, and it's an instance where the person's address does not meet the standard under the law. And the reason the standard under the law is so important is because if they're going to be mailing out millions and millions of ballots, we have to be certain that every single one of those ballots arrives at the correct person's doorstep and they're able to receive it. That there's no question that someone else would be able to receive the ballot. Like if you delivered a stack of them to an apartment building, for example. No, they have to be delivered, they have to be slid under the door of each apartment owner who's registered. That's how precise and accurate the system has to be. Because if they don't get to that person, where did they go? We also have a couple down here that I want to highlight. We have, in California, you have 132,000 people registered to vote who have a very unique characteristic. Now, the place of birth of a registrant is not, it's not material to your eligibility, right? You don't have to have a particular birthplace to be able to vote. But California does track this data point for their registrants, and they store this data in the voter roll database that is required to be accurate. Therefore, we find it very concerning that you have 132,000 people who, in one version of the database, taken in 1 year by EIPCa, they have one birthplace. And in the 2023 data that they're scouring out, these individuals have a new birthplace, a different one. Nothing else about their registration record has changed, except for their birthplace. Now, this creates a whole web of mysteries. right? First of all, if that is a true statement, that the registrars have been spending their precious time going in and making sure to increase or improve the accuracy of birthplace records for the voters, well, they're being very diligent about it, and they've done it 132,000 times. How did they get the information that the first birthplace was incorrect? How did they get the information about the new birthplace? And how did that happen? Like, really? And that brings me to the next data point, which is worse. So we do have 108,000 people between those two databases whose statewide unique identifier was changed. Seriously. It's not a new registration. Everything else about the registration record is identical. And if you've ever looked at these data points, I mean, you're looking at a giant Excel spreadsheet with sometimes 60 different fields. So every single one of those fields is exactly as it was prior, but the statewide unique identifier has changed. And the point I want to make to you regarding those two particular mysterious claims is that this has nothing to do with clerical error. It's impossible that those are clerical errors. It has nothing to do with poor management of the data. This is manipulation of your data, probably on the back end. And there's a very good chance that the registrars you're facing them have absolutely no idea. You're actually officially having your way smarter than them about what the heck is really going on in California vehicles. Next slide, please. So the next question we're going to ask is, were the votes counted from eligible qualified citizen voters in California's 2022 general election? And we see all the same categories, all the same claims. So from your illegal duplicates, you had 330 votes. From your deceased registrants, you had 3,000 votes. From the age-discrepant voters, 1,500 votes. Invalid addresses, you had 115,000 votes. So it looks like if you live at a bogus address, you're a lot more likely to vote. Birthplace altered has like a 50% turnout rate. So it turns out if you were originally born in Afghanistan, but now you're born in Tennessee, you're really, enthused about your civic duty. Changing registered IDs, also 50% turnout rate, 49,000 votes from the changing registered ID category. And this is just 2 copies of the database. To be clear, in New York, we have tons of copies of the database, and you can rack up many, many more of these registrations because the database is not static, as they like to say. It's a living document. And it's alive, believe me, these things are alive. And so as many copies as you try to track these registrations, they're continually altering themselves. It's like trying to grab a wet fish. So anyway, to summarize, in your 2022 election, you had 257,000 apparent voting violations. And I say apparent because it's possible that some of these have a legitimate explanation, and there is an audit trail that can demonstrate that perhaps some of those illegal duplicate votes are legitimate, and that the voter was not trying to commit fraud, and no one on the back end was trying to commit fraud. It was some kind of confusion over a provisional ballot. I have no idea, but there could be legitimate explanations for some of this, but there are not legitimate explanations for all of this. I guarantee you. Next slide, please. So our third question, remember, was the number of votes counted equal to the number of voters who voted in the 2022 California general election? And the answer is no. They were not equal. And there were 132,195 more votes counted than voters who voted. So there's no record of how those votes got into the system. Now, to be clear, the way that California provides data is a little bit sneaky. So the voter roll database that was given as a document source, an official document, and I remember going back to the Help America Vote Act, the statewide voter registration database is a federal document. It's mandated in law. So your chief election official is a de facto federalized official, stewarding a document that's protected by the federal government. It's not just a state document, and that's the official record that we're using to create all of these particular claims. Now, the way that they have given us this document, or given it to the EIPCa, is they take all of the canceled registrations and they put them in a different box. They put them in a different sandbox. They play differently, they have different toys. And then you have all of the active and inactive registrants in a different box. And that's the one that EIPCa gets to look at. So it's possible that some of those 132,000 extra votes could be found over in the canceled registrations file, but they didn't give it to us. So we don't know. So we go ahead and report what they gave us, and if they have a problem with it, if they believe it's inaccurate, then it would be lovely if we could provide that other canceled voter file, and we could go looking for them, and maybe we could reconcile perhaps, who knows. Next slide, please. Remember the fourth question. Regarding the accuracy requirement for a federal election, that 1 out of 125,000 ballots in error, maximum error rate. In your 2022 election, California, under that maximum, would have had a total of 89 ballots in error granted statewide, and you could still certify the election as accurate. You could still have confidence that those 89 ballots in error represent legitimate human error. Not a big deal, doesn't need an investigation. But if you get to 90, and I don't know, I think we better start digging, right? So it looks like in your 2022 election, you had 257,805 unresolved voting errors at the time your election was certified as accurate and legally compliant. Certification is an official assertion by a federalized agent, basically at this point, your chief election official, that the results and the administration of the entire election system and process are completely accurate and totally compliant with the law. That was a lie. And guess what? You have a civil right to accurate current voter registration forms. You have a civil right, a guaranteed civil right, to each registered voter having a statewide unique identifier. And the 14th Amendment grants you a civil right to only qualified citizen voters casting votes. And if your vote is denied or abridged in any way, that's a violation of that right. Next slide, please. So in 1964, the United States Supreme Court gave us a wonderful opinion and decision of a grand lawsuit that was regarding or involving civil rights issues around race. Right? In the 60s, most of the Supreme Court decisions regarding voting rights and civil rights were all based on race. But nonetheless, the language applies today. And the right of suffrage can be denied by a debasement or dilution of the weight of a citizen's vote, just as effectively as by wholly prohibiting the free exercise of the franchise. And there's a bunch more Supreme Court citations here cited, going back to Siebold, which was in 1887. Gwynn v. United States and Lane v. Wilson talk about the right to vote can neither be denied outright, USC Classic, nor destroyed by alteration of ballots, and nor diluted by ballot box stuffing, that's Siebold and USC Saylor. So these are just a handful of the Supreme Court and Federal Circuit decisions that have been handed down during our robust history of the prosecution of election misconduct. You see, it's very difficult to overturn the outcome of an election. Judges hate that. It's not their job, right? The third sentence of our Constitution clearly gives we the people of the several states, the authority to choose our representatives. And so a judge doesn't want that job. It's not the right person for the job. It's supposed to be the sovereign. So it's very, very difficult once an election has been administered and certified to get it overturned. Your best hope typically in federal circumstances is to have a federal judge invalidate a state election. If it's clear, if the evidence is so compelling that the state election has been run so poorly that there's very good reason to believe the civil rights of some part of that citizenry has been abridged or denied, the federal judge basically is like your professor, right? You turn in your report, the state turns in your report, they say, here's our certified results. And then the federal judge says, you get an F, go back and do it again, right? That's basically as far as we can take it. They can't get into the administrative details. They don't have jurisdiction over it. So it's so important that our elections are accurate from the beginning. Next slide, please. So what do we do? What does the law tell us to do if we believe that our right to vote has been denied or abridged in any way, or is about to be denied or abridged? Well, the Voting Rights Act of 1965 tells us what to do. It says, file a lawsuit. File a temporary restraining order against the administration and or certification of that election. Don't let them take your vote. It's too important. Don't let that opportunity go by. And so although the Voting Rights Act grants that authority specifically to the Attorney General of the United States in this particular citation, it is a long-established belief and practice in the courts that every citizen has a private right of action under the Voting Rights Act, because it is the third sentence of the United States Constitution. It doesn't get any more fundamental than that. So the first thing that United Sovereign Americans is doing is we are working in 23 states right now to build those scorecards that you saw, like the California scorecard, and we're creating a template lawsuit, a template injunction for preliminary injunctive relief that can be used across federal circuits, can be used across states, because we're all using the same document, and the arguments and the law are all the same. And so we're planning to file these TROs in a minimum of 11 states. We would like to file them in 23 states. That depends on the funding that we are able to bring together, basically. But the template is written, and Texas, New York, Illinois, and Ohio are ready. California is nearly ready. Florida, North Carolina, Missouri, and Maryland are in peer review right now. So we're actually doing something quite extraordinary. And United Sovereign Americans is a 100% volunteer organization. This is us. We're doing it. Just like you guys have been working with EIPCa, you're invited. This is our country. And no one is coming on a white horse to save us. And we have millions and millions of dollars worth of voluntary data analysis and data review and programming into these scorecards already. And we have 23 states working on them. Why do we want to file in 23 states? Why do we want to file at least in these top 11 states? Because if we file the exact same lawsuit, the exact same set of claims, or they're slightly different, right? The particular claims are different based on what the states actually give in their roll databases and what we uncover from state to state. The concept is the same. Because if the same matter is being decided across federal circuits now, you see, because walk back a little bit, remember I'm from New York. So we were saying there would be piles of evidence. We're thinking, okay, so we take this to a federal judge in New York, and let's say by some extraordinary miracle, we make it through the New York court system, we make it through the Second Circuit, and we win. Let's say they say, yeah, you're right. You've proven that this voting system is incapable of producing an accurate, trustworthy result. And I'm going to show you exactly how we prove that. There's one more slide I'll show you, but not quite yet. Me and Matt are getting along really good now. If we win in New York, what does it matter for the 2024 election? Who cares? New York is not really that critical of a state, actually. in terms of the context of 50 states. There's 49 states in complete chaos. Their voting systems are just as they were. So that's just not gonna work out, because that doesn't protect my grandkids, and sometimes it comes down to that. I don't have them yet, but I know they're coming, and it's my responsibility to make sure, you know, I still have to do it. But, so we had to do this, and now we have 9 federal circuits covered by these 11 states that we know are gonna be ready in time. If you have diversity of opinion across federal circuits, what happens? Immediately. And these are TROs concerning our most fundamental rights. And in fact, the lawsuits are so simple and so elegant that it's almost impossible for them to take too long. Because there's only one document involved, the state voter roll database. All of the laws that protect that document on the basis of protecting our right to vote from any kind of manipulation or any kind of distortion. There's really nothing to discover. There's really no controversy over facts. It's their document, and the federal government says it has to be accurate, and that's their job, to be accurate. Now, those TROs, we're hoping, are going to elicit a ruling from the Supreme Court, or at least in many of these states, that says that these voting systems are not capable of producing an accurate result as they stand, and they have to come into compliance with the law if they are to be used in the 2024 general election. This is simply too much at stake. Next slide. Now, there's another element here that's outside the scope of those TROs. Those have to be as simple as 1, 2, 3 in order to actually have an impact on the 2024 election. And we're running out of runway, so I just want to say, people who want to volunteer and participate, but especially people who want to support the legal efforts, we don't have a lot of time. If you think this strategy is compelling, it's a good time to take a big risk. So, another Supreme Court ruling gives us another right of action beyond the scope of the TROs. And this is what Linda was talking about, holding election officials accountable. I'm going to read this and we'll talk about why does it say this? What is the underlying meaning here? So from EIPCa, which is a decision from 1888, so it's just past the Enforcement Acts. So there's a time of great upheaval, and there's a lot of issues with, voter fraud, with denial of rights to ex-slaves. There's a lot of litigation and legislation. In EIPCa, they said, Congress seeks to guard the election of members of Congress against any possible unfairness by compelling, under its pains and penalties, everyone concerned in holding the election to a strict and scrupulous observance of every duty devolved upon him while so engaged. The evil intent consists in disobedience to the law. So this tells you something, and this is still good law. This case is cited in the current edition of the Prosecution of Election Offenses. This case tells you that there's no such thing as an honest mistake in federal election. Why? An election is an inherently zero trust system. You have natural adversaries who have absolutely no reason to trust one another, and in fact, they have a lot of good reason not to trust each other. So how is it that we achieve continuity of governance? How is it that we maintain domestic tranquility? Because the election officials have to walk a tightrope between those two adversaries. They have to walk a tightrope that is defined by procedural and administrative law. And if they step off those procedures and allow information to enter the voting system that hasn't met the standard of the law, they step off that tightrope. There's only one reason they did that. Only one reason. Because there's so much at stake. They have no right to step off that tightrope. Because the third sentence of the U.S. Constitution says the people of the several states shall choose their representatives. election officials don't get to choose. And they don't get to decide whether or not the law, the procedural law, is adequate to deal with a particular circumstance. They have to follow it. That's the only way we have harmony. Otherwise, nobody has to trust the outcome of the election. So, can you go to the second document? You're gonna have to go up to the top page. There we go. Great. So this is gonna be a little small, but again, if you really want to see what it says, which is, I think, very compelling and powerful, you may want to come. Basically, we reconciled. Okay, so this is in California, this is now New York. This is the election validity reconciliation sheet, another template document United Sovereign Americans has created, and all the states are filling this out. So these are the two documents, the scorecard and the reconciliation sheet, comprise the bulk of our evidence. So just like if you have to balance your checkbook, you have to balance an election. So we took a look and we looked at the entire database for New York's 2022 election, and we had, on our scorecard, we had 5.1 million apparent registration violations. And we crammed them all into these 4 buckets. Registrations that appear to be eligible. We can't find anything wrong with them, so they might have actually come from a person. Registrations that are uncertain, because you look at one copy of the database and it looks okay, and you look at another copy and their birthplace has changed, or their birth date has changed, or something immutable has shifted, and it's inexplicable. So we can't tell if they're that person or not. And then ineligible, because the records violate black letter election law, they do not meet the standard of eligibility as defined by the federal government or the state government. And then we have deadwood, which is registration records that don't belong in the database at the time of the election administration because they're not qualified and they can't cast a ballot. And the DOJ, the Department of Justice, calls those deadwood because they're just kicking around and they could be used for fraud. Somebody knew what was in there, they could use it. So we were able to zero out the database. We were able to reconcile the database on that basis. We tried to reconcile the 2022 vote, but we couldn't because there appears to be 35,000 more votes counted than voters who voted in New York's 2022 election. The really compelling part of this sheet is down below. We discovered, based on this, that the registration error rate at the time of the certification of the 2022 election was 14%. The voting error rate was 12%. A congressional race had a margin of victory of 0.6%. And you have your standard of accuracy under federal law of 0.0008%. That's 1 divided by 125,000. So what we have is a broken system, totally broken. I have no idea who won any election in New York's 2022 general election, and neither does the New York State Board of Elections. They have no idea, and they'll never be able to prove it, because their system error rate of voting is 12%. It's impossible to get a trustworthy result at 0.6%. It's impossible. It can't be done. This is the elegance of this particular set of arguments that we are bringing in these TROs across this country, forcing the matter to the Supreme Court. It has nothing to do with political party. It has nothing to do with any candidate. You can talk about this with your progressive relatives. I know because I do. Everybody thinks election validity is a good idea because it protects every American's best interest and it leads to unity, harmony, and balance in our country, which we are sorely in need of. If you think your anger is going to fix a broken country, you're wrong. You're living in an illusion. It's going to harm the country more. We have to use our discipline and our dignity, our skills and our wisdom to fix this problem now before it becomes worse in the 2024 election. We are the mothers and fathers of our America, and it is up to us to determine whether or not we continue to bequeath that gift of liberty to the future. And we're given an opportunity with this particular strategy. It's a miracle, that's all I can say. And I truly ask and suggest that all of you come and participate in this effort. And there is a resolution process. I don't want to go into it right now because you've had a lot of information already. What I'm going to say about it is that basically as the litigation strategy is unfolding on one side, there's a citizen advocacy and education strategy. And you guys in this room have become election validity experts today. Isn't that great? Because think of all the people who are not yet aware of election validity. They have no idea that there's an accuracy requirement. And no idea why the voter rolls have to be accurate, not clean. So the strategy for advocacy and education involves taking our resolution for a valid 2024 election and bringing it to any kind of official that you want to get on record, signing yes or no, I think our election should follow the law in 2024. And there's going to be citations for all the Supreme Court cases, there's information about the accuracy requirement, there's a lot of wonderful information and language in the resolution document, and yet it's very brief. And there are also 11 points of election validity that we are demanding be followed. And it's basically a point by point of follow the law. Just follow the law. Just follow the law. Just apply the law. And again, we've had so much time here already discussing things, I don't want to open that document right now, but I want to say that if you decide to volunteer with the United Southern Americans, there is a training meeting for our volunteers every Wednesday evening in the resolution document. And you will be in great company because you'll be among people from Illinois, New York, Ohio, Texas, soon to be Maryland, Florida, North Carolina, Missouri, all of these states. We're all on that call together discussing our experiences bringing these resolutions to different official bodies and helping each other, supporting each other with different strategic ideas, different opportunities, going over the document and discussing the particular points and making sure everyone feels really confident in what they're bringing. And it has your states, it doesn't have the scorecard, it has a summary of those four points. It has the answers to the 4 questions. And so with that, I really open up for questions. I want to encourage everybody to come and participate. And I especially want to encourage you, if you're not able to commit to another initiative, do please donate to our legal effort. And
So what I want to say to all of you, California is involved in this already. Our data analysis team is already working on it. You saw the draft and the scorecard. What we need to do next in California is build our resolution teams. And that's what I was talking about. I know I've been alerted that our next meeting's already started. So we have, I think this question on the table today, and I think we're going to get back to you with an email for answers. Karen, is that how you do the questions? So are we out of time for questions?
If you think so.
We're out of time for questions. So turn your questions to Karen, and we'll send an email with the answers. The second one meeting is going to start, so we want to switch to that. But here, everyone, it is critically important that the EIPCa is already involved with USA, our teams. We take up our EIPCa hat, we put on our USA hat, and we are working hard to, in 2024, ensure that only valid elections are certified. And if they're not, then USA will take action on that. But we have to be able to alert election officials that there's a problem first. That's how you get standing. So I'm encouraging everyone to go to the USA website, sign up to get involved. Once I get back home, there's about 94 people who already signed up. We'll send out an email and say, okay, here's what we're looking at for California. But if you really want to challenge the continual certification of invalid elections in California, we need to do this as quickly as we can. And we need attorneys to help get involved. Remember I told you early on, we could have filed a lawsuit as early as 2013. We couldn't find an attorney to work with us until later. So we're going to need California attorneys who can help do the paperwork. In the next meeting, we'll be talking about something else. And we need donations. The EIPCa is raising donations, of course, for ours, but everyone, we're going to go through the long haul. Right now, I want to encourage you, I'd like to encourage you to support the effort of USA in California, because we need to be able to pay for the boards and working here. So if we are able to challenge, even private, we get those resolutions out, whatever we need to do it for USA. Okay, and so thank you all for coming. Back to you.
Thank you so much. That was fantastic. We're going to make a little switch over here, a little change. The following people, please stay here. We have a second meeting that's starting. And so I'm just going to call your name. Please stay here. That's Connie Kelly Brooks, Dr. Lee Carol Copeland, Peter Fears, Eric Gordon, Mark Thompson, Jeff Conifar, and Stuart Weil. So please stay here for the second meeting. And also Eric Rollins, Peter Rodberry, Marley Nalla, Sean Burdine, and I don't know if Phil Scott is here, Rose McClure, Tammy Richardson, and Walker. So Carl knows, stay here, please. So if I call your name, please stay here. The rest of you, thank you so much, and we'll be in touch with you. Thank you.
No, we use the statewide database for this effort because the statewide database is the federal document.